Welcome to the third chapter of the second module of this course, where we shall be discussing case studies and legislative gaps in sexual and reproductive health and rights. From the broad definition of SRHR, which we already discussed in the first chapter of this module, a number of issues are encompassed in this definition. We can look at a number of things including surrogacy, sexual and gender-based violence, safe abortion, and maternal health. Sexual and gender-based violence, to start with, refers to any form of harm inflicted upon a person as a result of the socially ascribed differences between men and women or the male and female gender. SGBV includes physical, mental, and sexual harm and has its roots in the structural inequalities between men and women. A survey revealed that at least 40% of women experience physical violence at least one time in their lives. At least 21% of these women experience sexual violence. The disaggregated data indicates that married women or women who have been married, such as divorced women, widowed women, or separated women, suffer violence more likely than women who are still in marriages or women who have never been married. SGBV, particularly sexual violence, can have severe consequences on the physical and mental health of the women or its survivors. We look at the case of WJ and another versus AMCOR and Teacher Services Commission, whereby two children aged 12 and 13 at the time of the assault were repeatedly raped by their teacher in whose custody they were. When the parents of these children discovered the rapes, they brought the matter to the police, and unfortunately the case did not conclude. The parents then decided to bring a case against the Teacher Service Commission and the individual teacher for violating the children's right to health. In this case, when considering the detrimental effect of the violence the children had suffered, the court found that sexual violence is a direct violation of the right to health, in particular the physical and psychological health of young children or women. We now look at surrogacy. For a long time, surrogacy agreements in Kenya have been shrouded in secrecy and have remained unregulated. However, as the practice becomes more popular, there is a need for the state to regulate surrogacy arrangements. To this point, we focus on two cases, JLN and two others versus the Director of Medical Services in another, and AMN in another versus the Attorney General. In the first case, JLN as a surrogate was commissioned to carry the twins of the commissioning parents. At the end of her pregnancy, she gave birth to the twins in a hospital. When the time came for the birth certificate to be filled, a dispute arose. Whose name should be on the birth certificate? JLN, the surrogate, or the commissioning mother? The hospital was unaware what to do and therefore reached out to the Director of Medical Services, who thought the best thing to do is to put the children in a home while the dispute persisted. The commissioning parents, obviously alarmed by this state of affairs, approached the court for relief, and the court found as follows. The name of the commissioning mother should be on the certificate. Additionally, the court noted that surrogacy is no longer a hypothetical situation, and thus the state has to put provisions in place to regulate these agreements. In the second case, AMN, a similar set of facts arose whereby there were parents who commissioned a surrogate to have their child, and at the time that the child was born, there was an issue with whose name should be on the birth certificate. In this case, the court differed with the opinion of the first case, finding that the name of the surrogate mother should be placed on the birth certificate. However, the court still noted that there was an issue in Kenya. We do not regulate surrogacy agreements. This remains a persistent problem. Cognizant of this problem, the 11th Parliament sought to regulate gestational surrogacy through the Reproductive Health Care Bill. However, this was not passed by the end of the Parliament's term, and therefore we remain with a gap in the law. Thirdly, we shall discuss the right of access to safe abortion in Kenya. Almost 8,000 women died during childbirth or pregnancy in Kenya annually, and another 160,000 women either become injured or disabled as a result of a pregnancy. Unsafe abortion accounts for over 13% of all cases of maternal mortality in Kenya, and a 2012 study revealed that 464,000 unsafe abortions occurred in that year. There is a demonstrated need for access to safe abortion, however, this remains illusory. Article 26 guarantees this right, but the practice continues to be perceived as illegal and is highly stigmatized. This stigma is fueled by a number of reasons. Firstly, the penal code criminalizes women, medical providers, and pharmacists who seek to access an abortion, provide an abortion, or provide medicines for an abortion. Secondly, there is stigma around our communities regarding abortion, whereby communities continue to believe that the practice is illegal in all circumstances and it amounts to murder. Finally, the Ministry of Health's conduct fuels some of this stigma. In 2012, the Ministry of Health adopted standards and guidelines to address maternal mortality as a result of unsafe abortion. This was in recognition of the high rates of maternal mortality as a result of unsafe abortion. However, before this process was finalized, the Ministry of Health withdrew the standards and guidelines, leaving a gap in the law. Further to that, they suspended all trainings for medical practitioners on comprehensive abortion care. Thus, given the constitutional promise on safe abortion, the legislative framework around this, the national guidelines on the management of sexual violence, amongst others, we continue to persist in a situation whereby abortion is perceived as illegal and stigmatized. The Ministry of Health has failed to address this, meaning that women and girls are pushed to backdens to access abortions, usually detrimental to their lives or health. The final case study we shall be discussing is the Linda Mama Boresha Jamii project. In 2013, the President of Kenya declared that all maternity services will be offered freely in public health facilities. This decision was informed by Kenya's high rate of maternal mortality and morbidity, with maternal mortality standing at 488 deaths per 100,000 births. With the advent of devolution, which was discussed in the first module of this course, health functions were transferred to the county governments, meaning when the President made his declaration in June, the obligation to provide the services lay on the county government. As this project rolled out, a number of challenges were noted, particularly by healthcare workers. Some of the challenges include staff shortages, inadequate supplies, overwhelming workloads, lack of managerial support, and financial constraints. A notable challenge is the funds flow from national to county governments. While county governments were expending resources to provide free maternity services, these expenditures were not being offset as speedily as they were being expended, which meant that county governments were going at a loss trying to provide the services while national government made disbursements slowly or infrequently. Therefore, at some points, county governments were unwilling to continue to offer the services given national government's behavior in this regard. To address these challenges, the national government has opted to move free maternity services from county governments to the National Health Insurance Fund under the Linda Mama Boresha Jamii project. While this is a welcome move because the national government has more control over the NHIF, there are still some concerns around how this is going to work. We are, however, concerned about the structure of the National Health Insurance Fund. The NHIF is not a government entity, it is a state corporation, which means it is not regulated in the same way as government entities. That means that it does not have the same accountability structures as the national or county government, which means that its structures, which are often opaque, will not be easily penetrated in terms of audits or inquiries. Another concern is the frequency at which this will be available to pregnant women. The NHIF is by its nature a user fee initiated program, which means you have to pay user fees, usually monthly, however you can pay an annual lump sum fee. This has been waived for pregnant women, which means they will not be required to pay user fees, but there is no commitment that this will happen more than once. Thus, if you consider this, a woman becomes pregnant in the first year of the Linda Mama Boresha Jamii project. In her first year, she becomes pregnant, she joins the NHIF, her user fees are waived. Part of the reason the NHIF is being utilized is to drive up users for the NHIF. That means drive up registrations. Therefore, at the end of this pregnancy, she will be allowed to continue with her membership only if she starts to make payment to the NHIF, which means if she becomes pregnant a second time during the project, she may not be eligible for its benefits, which then begs the question, how free are free maternity services? In conclusion, SRHR encompasses a number of varying issues. Therefore, the case studies discussed today are in no means an exhaustive list. We urge you to consider other, more diverse issues that may come up under SRHR and consider how you as a doctor can help in alleviating those issues.